and welcome to today's webinar. My name is Jose Galena, and I'm the VP of Product Strategy at Replicon. Replicon is the leader in cloud-based time tracking applications. We have over 7,800 customers worldwide and address many different types of time tracking needs, including time and attendance and labor compliance. Replicon is excited to sponsor today's webinar entitled Best Practices for Paying Employees Correctly and on Time. And we are pleased to have Brian Dixon of Littler Law Firm join us as presenter for this webinar. This is the sixth and final webinar of our compliance series. We've covered a lot of ground in this webinar series, from understanding the definition of an employee to defining work time to handling complex topics like the minimum wage and overtime compliance. In this webinar, Brian Dixon will bring it all together and show us how all the topics covered play an important role to ensure companies can pay employees quickly and accurately. However, before we get started, I want to review a few housekeeping items. First, I'd like to let you know how you can participate in today's webinar. You'll be kept on mute during the presentation, but you can submit your questions at any time during the presentation by using the questions box located at the right panel of your screen. Questions will be addressed at the end of the seminar. Second, I'd like to remind everyone that you are eligible to receive HRCI credit for attending this webinar. This webinar has been approved for HRCI recertification credit. You will receive an email with the certification information. Please stay on for the complete webinar in order to receive the credit. Now let me introduce our speaker and get started with our program. I'm very pleased to introduce Brian Dixon. Mr. Dixon is a shareholder in Littler's San Francisco office and co-chair of the firm's nationwide wage and hour practice group. Mr. Dixon is a graduate of the Stanford University School of Law and has served as wage board for the California's Industrial Welfare Commission. Mr. Dixon provides a full range of counsel and representation with respect to employee and labor matters. His particular expertise is disputes regarding minimum wage, overtime, prevailing wages, and incentive compensation. Mr. Dixon is the author of the Federal Wage and Hour Laws published by SHRM and the general editor of the Wage and Hour Answer Book. He is contributing author to the Fair Labor Standard Act and Wage and Hour Laws, a state-by-state survey published by ABA and California Wage and Hour Law Litigation, published by the California Bar Association. Please welcome Brian Dixon.
Thank you, Jose, and good morning, everyone. I have the opportunity to speak to you this morning from beautiful Sacramento, California, where it is a unusually cool and pleasant and beautifully clear summer day. We're going to be talking today, as Jose points out, about best practices. We're going to be pulling together some of the things that we've talked about earlier in this six-part webinar series. One of the things I'll say at the outset, and I've said at the outset of each program, is we have to be very mindful that wage and hour law is a subject that has few overarching concepts and can sometimes best be thought of as a morass of detail. One of my colleagues calls the Federal Fair Labor Standards Act, which is the source of the nationwide minimum wage and overtime obligation, the FLSA, forever lost, seeking answers. And we're not forever lost. We've had a lot of good learning, I believe, in this series, and to understand what issues we need to orient to allows us to make sure that we simply look and find an appropriate answer, even if we should not be able to maintain the entire morass of detail in the front of our mind at one time. One thing, though, I will sensitize you again to is the fact that there is a great deal of detail here. For example, there's a half dozen states that regulate regulate what we call reporting pay, which is the payment of a minimum amount of pay if you call an employee into work and the employee actually reports to work. California has reporting pay. Oregon has reporting pay, but only for minors. New Jersey, Washington, D.C., and New York have reporting pay, as do a few states in New England. I think it just goes back to a value judgment there from starting in New England, perhaps, where if you invite someone over, you should at least entertain them for a brief period of time. And we should be aware of the fact that reporting pay statutes themselves vary in terms of how many hours of reporting pay do you have to provide, and whether you have to provide that at the minimum hourly rate or at the employee's regular rate of pay. So again, our point here simply is this, and that is you don't want to assume that what works where the state where your business originally started is going to work every time you open a new office in another state. And today I think the starting point, and one which you want to bear in mind when you have a dialogue with management about compliance and about the resources you need for compliance, is the basic value proposition. And that is, in the world of wage and hour, it's not pay now or pay the same amount later. It's pay now or pay a lot more later. And why do we say that? Well, for one thing, when you get involved in litigation and an employee is schooled, perhaps, would be the best word, as to what might be hours of work, the number of hours that are at issue is likely to increase. I've never had a plaintiff say that he or she worked less than a gazillion hours, nor a plaintiff testify in court that the employee's worth is due less than $10 gazillion. We also have liquidated or automatic double damages, and again, they are automatic. Under the Fair Labor Standards Act, double damages are automatically awarded unless you can show you have a good faith and reasonable belief that you're in compliance with the law. Good faith, of course, means a pure heart, and being here today helps prove that you have a pure heart. But reasonable means you actually went out, or someone knowledgeable went out and looked at the pay practice and believed it was in compliance with the Act. So the standard is not one which one can meet simply by protesting one's innocence. We have civil penalties. Civil penalties drive a lot of the litigation here in California. Other states' civil penalties are important as well. I was talking with the good folks at Replicon about the people who attend these webinars and learned that 25% of the attendees are here in California and the rest outside of California, so I don't want to dwell unduly on California, obviously. But at the same time, we want to realize that if you have operations in multiple states, you have to comply with the laws of each of those states. And again, they can be significantly different. And again, if some of those employees are in California, you need to know the legal landscape in California to make sure you're in compliance. Finally, we have attorney's fees. Plaintiffs' lawyers don't come any less expensive than defense lawyers come. In fact, many of them seem to do quite well. When my colleagues and I look at the next class action settlement and we see the motion for attorney's fees in the hundreds of thousands or occasionally $1 million or more, our slang expression for that is, well, they'll buy another island. And we don't want to be contributing to their real estate accumulation. The first step in best practices is to train your supervisors. For supervisors, we need to know what hours worked are because, as we learned in the earlier session, such non-obvious things as travel, training, on-call time, certain preliminary activities, donning and doffing, uniform or other clothing can be compensable work time. We need to make sure that supervisors are well informed, very well informed, very well informed of the sufferer permit standard, which simply is you have to pay for what you knew, what an employee worked, or what you should have known. And that probably runs contrary to the sentiments of a lot of supervisors who may have risen through the ranks, volunteering some time in order to get ahead. But volunteering time is still work. The fact that work might be enjoyable and that an employee might want to work longer doesn't mean that you have any fewer hours of work that you have to provide compensation for. You have to be aware these days, of course, that meal periods and rest periods are a significant obligation. About half the states regulate meal periods, and about 10 of the states regulate rest periods. And some of the states that regulate meal and rest periods, certainly meal periods, are perhaps not obvious. Oregon is particularly sticky about regulating meal periods. They have a state prescribed notice. New York probably has the most complex meal period law with meal periods having to fall in certain intervals within a shift or during the day. And California, of course, has 1 hour premium pay whenever a meal period or rest period is missed. For managers, we also want to make sure that they understand that they cannot compromise overtime exemptions. And our series of programs has focused on how to compensate employees who we think of as non-exempt, those who are entitled to overtime, and we've focused on making sure we know how to count hours of work, appropriately report them, pay them at the minimum wage, pay overtime premiums, and pay them timely. But we do still want to remember that in compliance, we have to make sure we preserve the exempt status of overtime exempt employees. And what do I mean by that? Well, take, for example, a manager of a big box, as we call it, a retail store that might have a total of 50 to 75 employees and has a couple of overtime exempt assistant managers. One of the assistant managers is struggling. The store manager doesn't want to deal with the performance issues and says, okay, fine, I'm just going to assign you to stand in the checkout booth and you can serve as a register clerk. Well, that assistant manager who would have to have as his or her primary duty management is not going to be exempt if the only thing they're managing is the line of customers going through the checkout booth and entering data into the point of sale terminal. And what's happened here, of course, is that the store manager, instead of dealing with a performance issue, has basically demoted the assistant store manager to a non-exempt position. Well, we want to remember it only takes one plaintiff to start a class action, and a demoted, frustrated, and perhaps soon-to-be former assistant manager could make an ideal plaintiff in that regard. So again, we need to be sensitive to having managers not corrupt the overtime exempt status of their subordinates. We also want to train employees, and some of us may say, darn, in a world full of what seems incessant wage and hour litigation, why would we want to go out and train our employees? Well, a lot of employees are very dedicated, hardworking, and loyal. And being able to train them as to how to do their jobs appropriately, which includes not only applying their skills to their work, but also what are hours of work, when they should take meals, and when they should take rest periods, is going to pay big dividends in terms of morale. Secondly, we see a steady stream of off-the-clock cases. And off-the-clock cases are, quite frankly, often the result of coercive supervision. An overzealous supervisor, at best, is saying, don't report all your hours of work. And you're not going to capture that coercion by training the supervisor. You may to a degree, but you're not going to fully capture that. You're only going to succeed by training employees as to what they need to know about reporting their hours of work. And you need to make sure that they have an access to the hotline in order to report any violations. One of the things that I think is particularly helpful for an employer is to prominently post that help is available with respect to your pay issues by calling HR. We can't require people to call HR. Employees are free to go to the enforcement agencies, of course, but you always have an incentive to have your compensation issues escalated within HR so that it can be addressed quickly and effectively before they bloom into a larger problem. You can put that next to the time clock. Any questions about your pay, call this number. You can put it on the employee bulletin board. You can even put it in the message field of a paycheck stub so someone always feels supported if they have any concerns about how they should be paid. We also want to document that training. I'll give you an example of that. Let's say you design a PowerPoint that goes through your meal period policy, your rest period policy, if you're required to have one, talks about how to report hours of work, talks about where to go in HR if you have questions about that, and has perhaps, if we elaborate a little bit, a 10-question quiz at the end, which you must successfully pass in order to, when you click the Finish button, generates a beautifully embossed certificate, perhaps not embossed, beautifully printed, multicolor certificate announcing your successful completion, John or Jane Doe, of the company's wage and hour program. Let's say John or Jane, so to speak, falls out of love with us and turns up as a plaintiff in either a single or a multiple plaintiff or a wage and hour class action. Imagine how effective it would be if you were the attorney to sit down and John or Jane is saying, I didn't know, I was coerced, I had no place to go, I didn't know I had to put this on my time card, I sign my time card every week because I just thought I had to in order to get a paycheck. And then you push the PowerPoint training across the table and say, hey, do you remember taking this? And here's the slide that talks about how accurately reporting your hours of work. Here's a slide that says how important it is for your certification to be accurate. And by the way, here's a slide that says, here's where you go if you have a problem with your pay. And the employee is backing up and stuttering a little bit, and then you slide that printed certification across the table and say, and you passed the quiz, didn't you? Well, at that point, plaintiff's counsel may be thinking less of buying another island and maybe looking out the window and thinking that maybe this deposition will finish early today. We also want to be aware of the importance of timekeeping, and I know we've dwelled on that. If you don't keep time accurately for employees, you can't pay them accurately. We've talked a bit about rounding. Rounding has certain advantages and a good many limitations. One might think of it a little bit as a historical anachronism dating back to the time when we had lots of employees to pay and we didn't have computers. Well, computers are with us from now, I think from now on, it would be fair to say, and the need to round in order to pay employees in a timely fashion or efficient fashion is gone. And the fact that quarter hours might look more appealing on a paycheck stub is a little solace if you wind up in a rounding class action. And rounding may serve some purpose in the sense of people punch in and then have to walk some distance to their work area, or it may be that 75 people need to punch in using the same time clock, and you don't really want people at the front of the line to be paid less than people at the back of the line. But I think your answer really is more time clocks closer to work areas. Technology has grown. Cloud solutions are available. It's not necessary to worry about the cost of a mechanical time clock and who's at the front of the line and who's at the back of the line. And if you pay employees to the minute, which is certainly my recommendation, imagine that employees will want to be crowding through the line more quickly. They'll be at the front of the line instead of the back of the line. They'll be eager to go to work. Another option is if you're having problems with short meal periods, and I have to say this is a recurring issue. Okay, when, my state requires a 30-minute meal period, and we know under federal law that a meal period of less than 30 minutes may well be considered to be work time. What about 29 minutes? What about 28? What about 27? Where is that diminishing point? There was a case against one of the United States' largest retailers that went to trial in Alameda County, which is right across from San Francisco, includes the city of Oakland, California. And the jury decided that 27 minutes was enough. But, why bother? If you want to make sure employees have a half-hour meal period, you can have a lockout on the time clock so they can't punch back in before the 30 minutes are gone. It avoids worrying about the countdown from 30 to 29 to 28 and so on. You could also, if we want to be prudent, have a meal period of 35 minutes or 40 minutes or 45 or an hour. And it's hard to say that a meal period of 59, 58, 55, or 40 minutes approaches that half-hour threshold. And of course, we need to make sure that we get a certification from employees that their time cards are accurate. There's no legal requirement that a time card be signed, but a signature is essential to being able to establish that the employee is certified that those hours are accurate, that will stand behind those hours, and if a dispute arose, you could count on that signature as some evidence that that is the correct amount of hours. And your basic certification was covered in one of our earlier programs. It would run something like, I hereby certify that foregoing hours are complete, I haven't worked off the clock. And then it would go on to say one of two things. I either received and took or waived all of my periods, meal and rest periods, except the following. Of course, we have to have a blank there because you can't really coerce an employee to saying they received something they didn't get. Or if you set up your payroll software such that an employee can click, on any at the end of in the right-hand column, so to speak, missed meal, missed rest period, you can have a certification. You don't need to have a text field there. You can simply say, I've accurately reported all of my hours of work, and I've accurately indicated those meal periods that I missed in the time record. We want to remember that Washington, for example, treats missed rest periods quite severely, and that is any meal period that's missed has to result in an additional 10 minutes, of pay, And those additional 10 minutes are considered to be work time for the purpose of calculating overtime. We need to watch the carrots, for sure. There are some modern practices as we're able to synthesize more data and report more data and evaluate more data that sometimes get employers in trouble. One is labor budgeting. Some colleagues and I have a case that's been going on for 10 years. It's a wage and hour case, involves the exempt status of store managers and assistant store managers in a retail chain. And you might say, how can it be going on for 10 years? I was speaking to one of my colleagues who said, you know, when this case started, my son was 8 and he didn't know the difference between a deposition and an interrogatory. And now he's 18 and he's talking about going to law school. That's how long the case has been going on. But one of the major features in the case, which has been the subject of repeated observations by the judge in his publicly issued opinions, is whether the company's labor budgeting, as asserted by the plaintiff, was so rigorous that managers were forced to do non-exempt work such that non-exempt work became their primary duty and they had to be paid overtime. And we, of course, have defended the labor budget as very reasonable. In fact, you can make a case that as the budget gets tighter, a manager has to manage more and will fail more immediately if they try to do the job themselves. We also have to watch efficiency incentives for managers and employees. What's an efficiency incentive? Well, that would be, let's look at your typical automobile repair shop, which probably uses what we call a flag rate. That is, you get a quote where the labor is based upon the industry standard for getting that job done. And you're generally protected, you know, if the mechanic takes longer, and of course you might occasionally think that the mechanic's taking advantage of the system by getting the job done more quickly. And in fact, it's not uncommon for there to be an efficiency bonus, and that is, as the mechanic progressively beats the flag rate in getting his or her tasks done, the employee may earn a separate incentive. I was looking at one such incentive plan recently where the incentive could be 1/3 of an employee's pay. Wow. What an incentive, perhaps, not to report a few hours or to skip a meal or skip a rest period when you can earn an additional 1/3 of your pay through an incentive payment. So we need to watch the carrots and make sure they don't grow to dominate the compliance landscape. In the trenches of pay processing. Well, let me start this slide by saying, when was the last time that you went to your payroll manager and thanked him or her for all, and the staff, for all their diligent efforts in terms of managing wage payments across all the states that you do business in? It's an incredibly complex undertaking. The software has certainly evolved to be more helpful, but when you sit and you look, for example, at the number of pay codes in the system and the number of potential deductions in the system, and you multiply that by the number of employees and the number of states and the number of locales, because we have a lot of local tax and local obligations these days, you begin to get an appreciation for how complicated a task that is. So please say thank you. Things we need to watch for in pay processing, of course, are watch inclusions to the regular rate. We devoted one program to that. We know that that overtime is not an additional 1/2 of the base wage. It is, in fact, a additional 1/2 of the regular rate, and the regular rate includes all of an employee's remuneration, subject to some very limited exceptions, generally divided by the total hours worked. So if you're paying shift differentials, bonuses, commissions, lead person premiums, the overtime rate, or the regular rate upon which overtime is based, is going to be substantially more than the base wage. We also need to make sure that we have sufficient resources in payroll to be looking for missing or blank time card certifications. Certainly, a time card that comes in that's not signed, it's got to be considered a red flag that something's amiss. We also, if we have a certification that includes taking meal and rest periods, or perhaps reporting missed meal, rest, and here in California, heat recovery periods, someone needs to be catching those and paying those, because the obligation to pay the premium for missed meal and rest and heat recovery periods has to be paid every payday, just like every other part of an employee's wages. We need to make sure also that someone's looking for missing time entries and missing time cards. Also red flags about compliance problems out on the shop floor or off in the lobby or in the warehouse. The challenge is that if you have missing time entries, you're opening the door to an employee saying, well, that was just indicative of the fact that I was being coerced to work off the clock. Missing time cards really aren't an excuse for failing to pay someone, because it is an employer's non-delegable obligation to pay employee to keep an accurate record of employees' hours of work. So if you delegate that responsibility, you don't get the time card and you don't pay, you're simply acting at your own risk. We want to realize that missing time entries and time cards are an employee performance issue and should be addressed as such. Hey, part of your job is to accurately and timely report all of your time. If we're seeing missing time entries and missing time cards from a particular department, then we know we have to coach that supervisor to do a better job of training his or her employees about the importance of fulfilling all their job duties, including accurately reporting their work time and doing so at the end of each pay period. And of course, our standard should be that you complete your time entries every day. It shouldn't be that you wait until the end of the time period in order to report your time. One other set of pay practices that I will comment on briefly is what we call auto-population and auto-deduct. Our workforce is made up of human beings. We're undoubtedly aware of that. And we all know that there's no human being who's perfect. So if we automate the time card to suggest that, in fact, you arrived at 8 a.m., went to lunch at noon sharp, came back at 1 p.m., and left at 5 p.m. every day throughout the entire year, we risk employees either becoming lazy, relaxed, or excessively dependent upon that and not recording their accurate hours. The same for meal periods. Auto-deducts of meal periods, that is, we will automatically deduct your meal period unless you make some entry to the contrary, simply create a great deal of risk in the timekeeping system. Your best practice, of course, is that employees have to fill in all the time entries every day, and they should complete it every day in order to be accurate. We need to watch the flow of cash, because that's ultimately what the payment of wages is. We have to make sure that we pay timely. And the time limits within which you have to pay employees after the end of the pay period vary. Arizona and West Virginia sit at lowest thresholds, only 5 days after the end of the pay period. Massachusetts and one other state which slips in my mind just at the moment have a 6-day lag between the end of the pay period and the obligation to have the paycheck generated. The rest of the country, 7 days will be sufficient. Some states are even more relaxed. I was reading the Wisconsin wage payment statute a good many years ago, and it seemed that you could pay an employee once a harvest season. I doubt that that's the case anymore. Wisconsin has become quite an activist state from a labor enforcement and a wage and hour enforcement perspective. Ditto Minnesota, and surprisingly enough, North Dakota and Montana are actually very activist states in labor and employment enforcement as well. We have to make sure that we have a final payment in timely fashion. About half the states in the United States have a penalty if you don't pay an employee with the prescribed period of time after the end of employment. In about a dozen states, that's on the last day of employment. Another dozen states within 1 day of the end of employment, and easily in another states within a week after the end of employment, not on the next regular payday. And there are very common to have civil penalties for that. So now we come to what I call the felony of pay processing, which is paying employees current. And to pay employees current means that you are paying them on the last day of the pay period. Well, if you're going to pay them on the last day of the pay period, you're going to have to shut down the data flow into payroll several days before that, so payroll has time to crunch all of the data and generate a paycheck. And if you're shutting the data flow down early, before the end of the pay period, we know that the last several days of the pay period will be reported on a presumed or an auto basis. Hey, you must have worked the hours that were in your schedule, when in fact we know that's not always going to be the case. This generates problems just about everywhere. The first is that you can't, in many states, make a deduction in the next pay period if the employee was overpaid. The other is that in many states there are penalties for failing to pay employees timely, so making up for some missing overtime in the next pay period may not be sufficient. And the odds of the paycheck stub being accurate, we'll come back to paycheck stubs in a minute or two, diminishes incredibly when you pay current. Another challenge is paying semi-monthly salaries to non-exempt employees. it might look convenient to pay employees, non-exempt employees, on the 15th and the last days of the month for 1/24th of their compensation in the year. But that 1/24th is usually going to be the 2,080, or more accurately, 2,088 hours in a year divided by 24. And I say 2,088 because it's important to realize that every year includes 52 weeks and 1 or 2 days. Depending upon which day of the year the week started and whether it's a leap year or not, those extra 1 or 2 days may be a weekend day with no work, or could possibly be 2 additional work days, such that you have 262 hours, work days in the year, and something more than 2,096 hours that you have to pay for instead of 2,080. That's just a good thing to bear in mind, and we'll come back to that in another context in a moment. I always say that's the only intersection of Roman history, astronomy, and wage and hour law that you can find. Roman history because we basically work off the Julian calendar that Julius Caesar was responsible for. Astronomy because that controls the number of days in a year by virtue of the Earth's course around the sun. And wage and hour law, of course, the creature of Congress. The challenge with paying semi-monthly salaries to non-exempt employees is if you take, for example, 2080 and divide it by 24, you're going to come up with 86.67 hours of pay in a semi-monthly pay period. Well, you have 10, 11, or 12 work days in a semi-monthly pay period. So if you have an employee who misses 1 day of work, 11 days of work in a 12-day pay period, so missed 11 days, that's 88 hours of pay. We'll take the semi-monthly salary, it's 86.67 hours. We subtract 88 and say, hey, you owe us an hour and a third of pay for having worked 1 day. May not play well. So you turn around and say, well, we'll just pay employees for the number of days they actually work. We'll give them the benefit of the analysis. Same challenge. Here an employee misses 1 day in a 12-day pay period, worked 11. Multiply 11 times 88. Your paycheck is now 88 hours instead of 86.67 hours. So we're paying you an hour and a third more when you work 1 day less. The end of the story is don't pay semi-monthly salaries to non-exempt employees. And you wind up with very much the same kind of problem when you pay semi-monthly salaries to exempt employees. You're still going to have occasions when an exempt employee is going to be docked for a day because he or she had another illness absence or a personal day off and had no accrued paid time off benefits to address that. And you're going to have to make an adjustment in the final, or deduction in the final pay period, the next pay period. One thing I'll speak about briefly is making a transition from a semi-monthly to a biweekly pay schedule. There is inevitably something of a cash flow issue. And I say there's something of a cash flow issue because you want to pay biweekly only if you pay in arrears, which is to say I pay you within 5 days after the end of the pay period if we have operations in Arizona or West Virginia, 6 days if we have operations in other states, or 7 if we're lucky enough not to have employees in those states. And if you push the payday back from the end of the pay period, there's going to be a little bit of a cash flow gap. And you have to think about addressing that issue. One way to address it is just to give lots of advance notice to employees and tell them to plan for it. Another, which a good many clients have applied when they have a transition from semi-monthly to biweekly, is they provide a swing loan to employees. And I recently had the interesting challenge of writing a loan agreement that could be applied in all 50 states in order to support that process for a client. There are other ways to do this. One is to coordinate the transition date with perhaps the payment of an annual bonus. It is important, and you'll see the list on the right hand of this slide, to look at a variety of other issues. Determining the lag from the end of the pay period to the payday. You need to revise your pay stubs to make sure they accurately state the pay period. You need to address what I call the 27 payday pay period. If you pay employees every 2 weeks, most years will have 26 paydays. But if the very first day of the year is a payday, then the last day of the year is likely to be a payday too, and you need to plan for that. And that really accounts for the difference between whether there are 2,080 hours in a year or 2,088. You don't want to divide an annual salary by 2,080 when you convert to biweekly pay, because you're going to be using up the entire salary in 1 day less than the year provides. And as the years go on, that difference will grow, and eventually you'll have a 27 payday year, which can lead to a certain amount of panic in the finance department. So good planning is essential. And then we have to make sure that we provide the notices that are required in an increasing number of states. Some states require notice of an advanced change in pay rate. Some require notice in terms of advanced change in payday, advanced notice of a change in payday. We have Wage Theft Protection Act notices bookending the country in New York and California. We also have to adjust deductions for benefits. You may have to reissue your benefit deduction authorization forms to go from semi-monthly to biweekly. I always say it's best to make this change in coordination with your open enrollment period so that you don't have to do that reissue. And you have to adjust garnishments and support orders from what might be a semi-monthly rate to a biweekly rate. For example, support orders in Washington are simply and always stated in monthly terms. Here in California, support orders come with a sort of check the box. If you pay semi-monthly, pay this amount. If you pay monthly, pay this amount. If you pay biweekly, pay this amount. A lot more process and helpful in that regard. Well, what is your calling card to plaintiff's counsel? This is a phrase that one of my colleagues coined, and that is it's your paycheck stub. Because that's the first thing that the plaintiff's lawyer is going to look at in any pay dispute concerning a non-exempt employee. And paycheck stub requirements vary tremendously by state. Alaska, for example, is the only state that requires the hours worked in each work week to appear on a pay stub. Quite a few other states simply require the total hours in the pay period. Frankly, I think Alaska's requirement makes more sense. New Mexico is the only state that requires benefits, not defined particularly, to appear on a pay stub. It's not really clear exactly the sweep of that. We know for ERISA-regulated benefits, health plans, for example, retirement plans, reporting disclosure is covered exclusively by federal law. But in New Mexico, it would seem that you have to report the accrual of vacation, sick leave, and similar benefits that are not regulated by ERISA. I've listed here California's pay stub requirements. They are pretty rigorous. We actually sometimes call it the paycheck spreadsheet rather than the paycheck stub here in California, especially if you look at the requirement that all hourly rates and the number of hours worked at each rate be stated. Well, if we're being very mindful of the regular rate of pay, we have a biweekly pay period, and we have a higher regular rate in the first week of the pay period than we have in the second week of the pay period. We need to be mindful of the fact that we're going to have to show both of those overtime rates, OT rate 1, OT rate 2, on the paycheck stub. And I will tell you that you don't want to be embarrassed by the simplest of the requirements on the paycheck stub, which is there be a name and address of the legal entity that is the employer. Paycheck stubs still suffer from a lack of sufficient space for data. There's a case that involved an employer who didn't have a lot of characters that could be put in the name of the employer field, and the employer had a long name. So they left all the vowels out, which sort of makes sense, you know, in terms of you can understand what they were saying. But as the court pointed out, that sure wasn't the name of the employer. I had one client I worked very closely with to do a nationwide audit of pay practices. One of the things we looked at the pay stub, tuned it up, looked great. A couple of years later, we got sued. We were looking at the paycheck stub, and someone had changed the name of employer to the cost center because someone in accounting just thought it would be a great idea to have the cost center on the paycheck stub so we knew exactly where any potential issue went. Well, that's fine, except the paycheck stub's no longer compliant. So let's make sure that we are fully in tune with the calling card of plaintiff's counsel. It's also important to understand your areas of risk. And, you know, I'll really focus on exempt employees who work long hours at a high rate of pay. Well, there's going to be a lot of pressure to manage their hours and things like compensation for travel time, for answering the stray phone call outside of the regular workday, looking at your BlackBerry, accessing email, may all be compliance issues. And it's our recommendation that non-exempt employees not be able to access the network or work from home. Non-exempt employees should come to work, do their work, go home. The time clock should be off because you can never ensure that you're getting accurate reporting when employees work at home. You have to be very careful about exempt employees who work long hours and have a high rate of pay. The risk, or certainly those that have a high rate of pay, because, and if they are the first tier in the organization of exempt employees, they're probably a target for plaintiff's attack. And if they're working long hours and they have high salaries, then the potential damages are going to be very high. And my recipe for success here is pay liberally at a lesser rate of pay. You're better off paying employees $1 less and paying for all those marginal activities that may or may not be work time than you are paying the $1 more and defining your hours of work narrowly. You want to have a bulletproof pay plan. That's my philosophy. You want to save that quotient of worry time for things that are harder to control than paying people accurately. One essential aspect of compliance is conducting regular audits. Watch high-risk exempt positions. Never assume that the next audit will be the same as the last. I had a client, we looked very carefully at an in-house training position, decided it was exempt. The client called back not more than 2 years later and said, I want you to look at it again. I took a deep breath and said, wow, we looked at it so recently that I can even remember that, some aspects of the job. And the client said, yeah, but that job's changed so much. The population is just about turned over 100%, and you should look and see what the new population was. And the job had changed a great deal. Instead of people who were planning training and spending most of their time putting together training programs, it's now people who executed training. And that's a job that is quite vulnerable to being considered to be non-exempt. And that change occurred in a job classification of about 25 people just in the course of 2 years. You want to watch your high-risk hours of work issues, standby time in particular, and think about change. You have a standby workforce of technicians, and perhaps because of attrition and controls on headcount or a small rift, the number of employees go down. Suddenly that standby work is distributed through fewer people, and the ability to use standby time for their own benefit diminishes. And we add a few customers who are very demanding, and all of a sudden standby time becomes quite onerous and more vulnerable to the standby time being considered work time. Have controls where you need them. Often HR representatives will complain to me, I have problems with all my department heads just engaging independent contractors who I look at and just shudder because I know they're not really independent contractors. They walk like an employee, they talk like an employee, they quack, so to speak, like an employee. Forgive me for that. So they must be an employee, which is true. Go to accounts payable, put in controls. Just say, look, in order for someone to be signed up, an individual payee, to be signed up as an independent contractor, you need to ask at least these 8 questions. And the answer has to be yes to all of them, or you have to escalate it to me, and then I will mix it. So you can control the process. Ditto on interns. Any intern should be engaged through you. Any intern, if you're going to consider the intern to be a non-employee, should, that you should have a training program in place. I think that the best litmus test of a good training program is one where the manager says, every time this intern becomes just about barely productive, you move them to the next department to restart the training. Well, that's true because an internship program is to be primarily for the benefit of the intern, not the employer. Interns are not free summer help. Think of the class action against Fox Media, the class action against the Los Angeles Clippers, all of whose interns sued for back wages. You want to build a compliance file. Keep notes of your audits. Review those notes. Be able to find the file, which is to say store the file securely. You can't imagine the number of times we wind up in a class action and we say, who looked at the job because we need to establish good faith and reasonable belief. And the reasonable belief was carried out by an HR or compensation manager who's no longer here, and their files were all sent to storage, and we call the warehouse, and the warehouse can't find them. Impossibly difficult. Because we do, again, in order to avoid double damages, have to be able to show that both that we have a pure heart and that someone knowledgeable looked at the practice and thought it was okay. And, you can only prove that if you have some record that that occurred. You have to build on good faith. We appreciate your attendance here, certainly. It is good evidence of good faith. But you should be recording which programs you and your HR staff and your compensation staff attend. You should show that you keep up with publications and trends. You should show that you're training your supervisors and your employees in terms of wage and hour compliance. Think of what a great showing of good faith that would be made if a plaintiff ever claimed double damages. And you want to make sure that you discipline non-compliant supervisors and managers and document that as well. There's a famous case involving missed meal periods where the employer diligently disciplined employees who missed their meal periods. But as the plaintiff said at trial, every time a manager was called to explain compliance, it was, okay, you kept disciplining your employees. Who disciplined you? You have repeated failures of employees to take meal periods. Did you manage them effectively? The answer to the jury, obviously, was no. It was reflected in the judgment. We want to armor our overtime exemptions And by that means, you need to make sure that your job description and everything flowing from that are consistent with exempt status. I had a client that was an independent contractor sales or independent sales organization. They would sell products for their clients. They were such a go-go sales organization that the first line in every job description said, you know, maximize sales, maximize success. Well, usually the first bullet in the job description is the most important duty, and selling, if you're an inside employee as opposed to an outside sales employee, is rarely exempt work. So the job description actually shot us in the foot. You need to make sure that your job postings are consistent with the job description. You want to have periodic self-assessments from your exempt employees. Being exempt is all about the common denominator, the exercise of independent judgment and discretion by the employee. That means ability to have a range of decision-making. If, for example, you are an insurance company, such as, and this is from Bell versus Farmers Insurance, a California Court of Appeal decision of great notoriety, the Farmers Operations Manual said that adjusters really weren't supposed to make decisions. They were supposed to ask their supervisors when a decision had to be made. Well, if you have to exercise independent judgment discretion to be exempt, and your manual says don't exercise it, you're going to have a challenge, as unfortunately did that insurance company. Think about arbitration. Recent, very important decision by the California Supreme Court following law across the United States. The federal courts have long sustained waivers of class actions that are implemented as part of an arbitration agreement. Basically, what you have is an arbitration agreement that says, I agree to arbitrate any of my claims that I might have against the company, and I agree to do so on an individual basis and not in any class, collective, or representative proceeding. That has been accepted by the federal courts for some time, but it was resisted by a number of state courts. And finally, the California Supreme Court concurred with a number of recent United States Supreme Court decisions and said, you know, class action waivers are enforceable. Got to consider all the pluses and minuses of class actions, arbitration. Arbitrators are famous for, in a sense, splitting the baby in terms of handing out justice. There's no appeal. There's no rarely summary judgment granted by arbitrators. You do have a reduced risk of a runaway jury in the sense that the arbitrator is unlikely to award millions on a single sway of emotion. So we need to be aware of all those pluses and minuses. The door is still open here in California on whether private attorney general actions, which are actually considered in the California Supreme Court's recent decision, were considered to be attorney general proceedings, not, you know, little sidestep there. They weren't class, representative, or collective proceedings. They were a different category, which an employee can't waive. But of course, the federal courts explain and enforce federal law, and I don't think the decision of the California Supreme Court will stand in that regard. And finally, when we come to the end of our program, we need to keep up with the ever-changing landscape of wage and hour law. You want to make sure that you subscribe to appropriate periodicals. And if any of you on the program would like to have a free electronic subscription, it is free. It's the only free lunch in town. They come. You can turn them off at any time as well. Please send me an email at the address referenced in the presentation, and I will sign you up for Littler's very good, very frequent ASAPs about developments not only in wage and hour law, but in other aspects of employment law across the United States. You want to make sure you go to industry workshops. You want to listen, and you want to ignore industry practice. You may feel that it would be safe to tell management when you're sued in a class action, but we're doing the same thing our competitors do. At some point, management may turn around and say, you know, we expected a little bit more. But industry practice is never really a defense to anything in the arena of wage and hour. And lastly, I would encourage you to come back to Replicon's future webinar series. I've enjoyed them a great deal. I've enjoyed very much working with Jose Gaona, Armando Ortega, and Alex Dwyer at Replicon, who have supported this process and provided a great deal of constructive feedback and input to the programs themselves. I want to thank them very sincerely for their efforts. And with that, we'll bring this, the last of our programs, to a close. Jose, do you have some more thoughts to share with the audience?
Yes, thank you, Brian. Just a little bit about Replicon. Replicon is a leader in a cloud-based time tracking application. We've been in business for over 18 years. We have over 1 million users with over 1,700 customers worldwide. Our customer retention is 95%. Using Replicon's platform really benefits greater insight into your organization. It lowers the compliance risk through our payroll generator, and also we optimize processes. Replicon offers a suite of products which includes time tracking, absence management, cloud-based time clocks, compliance management, and scheduling.